adopt the recommendations as the orders of the court. He did make reference to the adopting the parenting plan that was attached to the order that was filed with the court on September 23rd. We asked that that be followed as well, Your Honor. We're pleased with the schedule. The parties are communicating by our family wizard now, and it's our hope that once this is settled, that the parties will work together in Lurie's best interest. That'll be our obligation and our attempt to do so, Your Honor.
Very well, Mr. Blanchard. I understand your position. Jordan?
What the Guardian ad litem typed up didn't quite make sense to me, because it said from Mondays to Wednesdays, something about those days being one or the others, but then also the other party gets her on Wednesdays and Fridays, and then something about the weekend. I'd just like for that to be clarified on what that schedule would actually look like.
You know, I'm happy to do that, or perhaps Mr. Andrews would want to clarify that. Either way is fine.
Okay.
I'm happy to do it, Your Honor.
All right.
Yes. My understanding, and of course, because Mr. Andrews and I work in this every day, it would be that Mom would get every Monday and Tuesday, Monday starting at 3 o'clock or after school until Wednesday at 3 o'clock or after school. And Father would have every Wednesday night and Thursday night from 3 o'clock or after school until Friday at 3 o'clock or after school. And then on Mom's weekend, she would have the child at 3 o'clock or after school until Monday at 3 o'clock. And on Dad's time, his weekends, he would have the child after school on Fridays at 3 o'clock or after school until Monday at 3 o'clock. And that schedule would go.
Welcome to Love Jim's Love. What you are about to hear is not just another custody hearing, but a moment where routine courtroom procedure collides with real parental tension. From parenting schedules to emotional transitions, this case centers on one child's stability and two parents navigating conflict under judicial scrutiny. The court must weigh structure against flexibility, concern against cooperation. As recommendations are clarified and objections raised, listen closely to how every word matters. Because in family court, decisions are rarely simple, emotions are never absent, and outcomes can reshape daily life. Stay with us as this unfolds carefully, deliberately, and by the book.
Alternating weekends, every other weekend would be Mom's and every other weekend would be Dad's.
Jordan, I don't see that there's any real crossover. It does appear that each part of the week is set aside specifically to an individual parent. So after Mr. Blanchard's recapitulation of Mr. Andrews' recommendations, do you have any further questions regarding it?
Yeah, that seems a little hectic with her also being in school and all the back and forth, and that seems like a lot going on. And we have to make sure that we keep track of all of each other's stuff to get it back and forth to where it belongs at, the right house. And that's already a lot as is for the Mondays and Wednesdays.
Why did you not consider a week-to-week plan, Mr. Andrews?
Your Honor, I know that was what the father was recommending. Frankly, I felt like that was a lot of time away from each parent, and I wasn't trying to make...
At this point, the courtroom slows down and focuses on logistics, but make no mistake, schedules like these carry real weight. The judge isn't just listening for dates and times. The court is testing whether this plan actually works in real life. Notice how the parenting time is carefully divided, weekdays assigned, weekends alternating, no overlap left unexplained. This is the court searching for clarity, not conflict. When custody plans fail, it's usually because ambiguity creates disputes. Here, the court is trying to eliminate confusion before it starts, ensuring each parent knows exactly when responsibility begins and ends.
Though I didn't give a lot of credence, I think, to some of the more extreme concerns that both parents were leveling, I guess, towards the other. I felt like a more frequent back and forth would maybe be beneficial towards alleviating some of those concerns that they would be able to see the child, make sure the child was okay, after the other parent's parenting time. And given the fact that Mr. Matlock was already receiving Wednesday overnight to Thursday mornings and then every other weekend, it seemed like it would just be a natural progression for his parent time to go Wednesday night through the weekend or Friday evening, and that Ms. Martin would continue to receive the Mondays and Tuesdays through Wednesday, or Monday evening through Tuesday or Wednesday evening that she's already receiving.
Mr. Andrews, was the young age of this child a factor in that decision as well?
I think that I'm a little bit more open to the longer period.
When the mother speaks, the focus shifts from structure to impact. Her concern isn't about fairness, but about the child's experience, school routines, transitions, and emotional stress. The court listens, but notice the response isn't immediate agreement. Family courts must balance parental worry against practical reality. The judge doesn't dismiss her feelings, but evaluates whether the concern rises to a legal obstacle. Hesitation alone isn't enough to stop implementation. The court is asking a different question: is this plan harmful or simply uncomfortable at first? That distinction matters more than emotion in this room.
Of time for older children, but with younger children, again, to be honest, in my personal practice, I usually start out with the recommendation of a rotating 2-2-3, because that really minimizes the amount of time that the child is away from a parent. But in this particular case, I thought that may be too much back and forth, too much to keep track of. And again, with the way that the temporary parenting plan was already set up, it just seemed like a static 2-2-3, where it was always Monday, Tuesday with one parent, always Wednesday, Thursday with the other. And again, in this case, where Mr. Matlock was already receiving Wednesday overnight to Thursday morning, it just made a lot of sense, even though that it results in kind of a 5 days in a row with one parent if they have the weekend. It still, I think that given Lyric's young age, as long as it is a schedule that is the same, it's a reliable schedule, she will be, in my opinion, children that age, as long as they know it's a routine. This is the routine. This is where I'm going to be at as they get older.
Here, the guardian ad litem explains the logic behind frequent transitions, and it's grounded in consistency rather than convenience. Younger children, according to the testimony, benefit from predictable routines more than long separations. The guardian acknowledges concerns from both parents but chooses a plan that keeps contact frequent and familiar. This isn't favoritism, it's philosophy. The court hears that stability doesn't always mean fewer exchanges, but reliable ones. The emphasis is on routine over preference. This explanation becomes critical later, because the court will lean heavily on professional reasoning when deciding whether to adopt these recommendations fully.
And then they don't have any ill effects from back and forth. It's when they don't know any given day of the week where they're supposed to be because there's no routine. It's up in chaos. I think that they have that problem.
All right. Ms. Martin, any additional remarks from you?
Yeah, I wouldn't say that she's adjusting any better to the overnight stays. If I'm still having to pull her off every time, the only time she transitions well is when Henry comes to my house and he picks her up and I put her in his car. Any other time, if I have to go over to his house to drop off clothes or drop her off in general, I have to pull her off of me and she's screaming, crying, saying she doesn't want to go. And that to me doesn't seem like adjustment. That seems like it's going to cause issues for her in the future.
May I respond, Your Honor?
You may.
Yeah. Your Honor, my concern is this, and reading Mr. Andrews' report and the statements made to him by Ms. Martin, that he didn't give a lot of credibility to what she was saying. This is not the experience that my client has had.
This is one of the most emotionally charged moments in the hearing. The mother describes physical resistance, crying, and distress during exchanges. For any parent, those words are powerful. But family court requires more than emotion, it requires context. The judge listens without interruption, weighing whether these reactions demonstrate long-term harm or temporary adjustment. The court doesn't accuse or invalidate, but also doesn't rush to conclusions. Emotional difficulty alone does not automatically defeat a parenting plan. The law requires patterns, duration, and evidence. This moment underscores how deeply personal experiences are filtered through legal standards in custody cases.
So we think that the schedule, as Mr. Andrews succinctly put it, is that it was more easy to follow on a Tuesday, Thursday over, and then the weekend, every other weekend. And that's what they'd like to do. I think the rotating 2-2-3 schedule is really confusing for a child and confusing for parents. So we think the recommendation is soundly based, and we'd like to see it followed, adopted and followed.
The court also believes, after review of the entirety of the report and the file in this case, that this parenting plan is currently in the best interest of this minor child, and the court will adopt Mr. Andrews' guardian ad litem recommendations in their entirety, finding that it is a sound parenting plan, which has been suggested to this court. And I do understand the mother's concern. It is a valid one. However, I think this is something that is worth attempting. And I think it would be incumbent upon a parent to show, after a considerable period of time that this parenting plan has been in effect, to show why
Now the ruling becomes clear. After reviewing the file, the report, and the testimony, the court adopts the guardian's recommendations in full. This is not a dismissal of concerns, but a determination that the plan deserves a trial period. The judge emphasizes flexibility in the future, reminding both parents that custody orders are not permanent verdicts. They are living arrangements subject to review. The message is direct: try the plan, document outcomes, and return if changes are needed. Courts favor measured implementation over speculative fear. Stability comes from consistency first, adjustments later.
Plan is not in the best interest of the minor child. It is not the view of this court that it should block its implementation at this point. I think it needs to be tried. And if there's adaptations that need to be made consistently with the best interest of the child, that can always be done in the future. But for now, the court will adopt Mr. Andrews' recommendations as the orders of the court in regards to a parenting plan. I'm going to place the responsibility of drafting of what I'm going to entitle shared custody decree on Mr. Blanchard. I think this will have an impact on child support, will it not, Mr. Blanchard?
It will, Your Honor. And I had one pay stub from Ms. Martin. I have provided her with 4 pay stubs for my client. She has been claiming the child each year. If that would continue, it would make actually, again, if they'd share the expenses, that would be fine. If she's going to pay the direct expenses, I can do a child support calculation either way. I know that Ms. Jordan said that she has ceased to work, but she does have the capacity and capability to work, and she has a pay stub which would show what she earns. I'm going to, with the court's permission, submit a worksheet, and if she wants to claim the child each year, then there's probably going to be no child support obligation. If they alternate the exemption each year, it would be $50 a month based on my calculations for Mr. Mr. Matlock. And then if they had a shared expense plan, if with her having the lower income that she would pay the direct expenses, then it would be somewhat higher. I calculated that at $127 a month, but with no adjustment for the value of the tax exemption.
All right. Blanchard, I want to make sure I understand what income figure for the mother would be used.
I used what her income was from Walmart. She was working 14 to one pay stub. She gave me $14 an hour times 78.5 hours biweekly. I took that times 26 weeks and divided by 12 and came up with 28,574, which turns out to be 2,381 a month. And my client's income is at $3,200 a month based on his pay stubs. And so I did the calculation based on those numbers, Your Honor. My calculation showed that my client had about 57% of the joint income, and she had about 43%. Let me see it. Let me pull that up. I'm sorry, I came up with 57.3 and 42.7. There is no daycare cost. Miss Martin has the child on the state health insurance plan at this point. So that's the calculation I came up with, Your Honor.
All right, Ms. Martin, apparently Mr. Blanchard's numbers are based on income that you had from Walmart, which appears to be a fair number for you. Would you agree with that?
I guess so. I don't work anymore, so
How do you financially survive without working?
well, my boyfriend,
Okay.
he works and he's taking over the bills since I'm not working anymore and all that.
All right.
Your Honor, per the guidelines and based on her recent income, I simply imputed that amount to her as what she's capable of earning.
Understood, Mr. Blanchard. Is it your intention, Jordan, to continue to pay the expenses for the child?
Yeah, we will.
Okay. I just want to make sure that when you make that representation that you have the financial capacity to actually do it.
Yeah.
And you say you do. Okay. I think that gives you some direction, Mr. Blanchard. And
Yes.
is it your intention, Jordan, to continue to claim the tax dependency benefits for the child each year?
I do plan to.
All right. I think you have that direction as well, Mr. Blanchard,
Yes.
in ultimately completing your child support worksheet.
Yes, Your Honor. I can do that. And what are we today? So would make that effective starting December 1 of 2025, Your Honor.
Yes, and it was really the intention of the court perhaps to delay the start of this plan until December 1st as well, so that the child support decrease and the parenting plan are implemented on the very same dates. And that would give the mother and father a short transitional period while this journal entry is being prepared and circulated, and actually have this go into effect on December 1 of the year 2025.
Okay.
Now, I do understand that there is a holiday parenting plan that would be incorporated into this plan as well. It's a rather detailed plan. It
Yes.
undoubtedly covers Thanksgiving. And so that plan would need to be followed for the Thanksgiving holidays this year, despite
Okay.
the fact that the shared custody plan would be implemented as of December the 1st. Furthermore, if you're going to use exact language, and I would prefer to the extent possible that you do, Mr. Blanchard, when you're incorporating the guardian ad litem's recommendations, he uses the term in paragraphs A, B, and C, should. I'd ask you to change that to shall.
Yes, Your Honor.
These now become court orders rather than recommendations. So I think it's important to change that one term in his text.
As to the recommendation, Your Honor, I can attach the recommendation, but I thought I would go ahead and explain it a little more fully in the order as well. Is that okay? Or we just
I don't want the guardian ad litem recommendations attached.
Okay, thank you, Your Honor.
He's got a relatively short actual recommendation section. That should be incorporated as much as you can, word for word, with that one change I ordered. But I really don't want the report becoming part of the order.
Okay, thank you, Your Honor.
Okay. And I do want all current parenting orders, visitation plans, holiday plans, other standard clauses incorporated into one order.
Okay.
Mr. Blanchard.
In one order, okay, I will not file a separate parenting plan. And also the parties were ordered and have been communicating by our family wizard. I want to include that in the order as well, Your Honor.
Indeed, that's an existing order that the court wants carried over. If it's successful, let's maintain what's successful.
I agree.
And that's good communication.